Good afternoon and welcome to Purdue University and the CERIAS Security Seminar. Our guest speaker this week is Jillian Long-Battle. Jillian is the Director of Privacy, Security, and Compliance for Rafori Corporation. Rafori is a startup corporation here in the state of Indiana that focuses broadly on cybersecurity. Before joining Rafori, though, Jillian has a very interesting background. She served as both the Deputy Treasurer for the state of Indiana as well as the Deputy Treasurer for the state of Missouri. So quite broad, very interesting background, and I suspect we'll hear part of that as well. Jillian, welcome to Purdue.
Thank you. So thank you and welcome to tonight's seminar. I am very much excited and honored to speak to you today. As Joel mentioned, I have worked in state government. I had the pleasure of serving 4 state treasurers, and so in my role as state deputy treasurer, I was trusted to manage and safeguard $3 billion in assets in Missouri and $8 billion on a daily basis for the state of Indiana. I took a real interest in risk management, right? When you work for a bank and you are handling that type of money and trusted to safeguard the state's taxpayer dollars, I was worried about risk. So as the attorney for the office, I often advised the state treasurers on things that we needed to manage and be monitoring on a regular basis. I want to note, because I think this is important information to share, because I think in my presentation, you're going to really figure out how much of a history geek I am. So forgive me, I'm just going to put that out there, because this is a safe space. I hope you feel safe, because I feel safe to tell you that I really, really enjoy World War II history, okay? So the first question I'm going to ask you, because I feel like I've already kind of vibed with you, and I'm going to guess that many of you did the same thing I did on Monday. Do you guys know what Monday was? What did we celebrate on Monday, September 17th? Say it loud, say it proud. Of course, it was the Constitution Day, okay? And like me, many of you probably got up and said to yourself, what am I gonna wear today? Yes, you did, right? And so, show of hands, how many people celebrated Constitution Day? Somewhat, a little bit, okay? I'm a little disappointed. I was expecting this year for Old Navy to come out, right, with the commercials, right? The Constitution Day t-shirts. I feel like Constitution Day is like the black sheep, right? We get all the 4th of July stuff, but there's nothing for Constitution Day. So I'll tell you what I did. I spent Constitution Day with fellow attorneys and law students at McKinney School of Law in Indianapolis, reading U.S. Supreme Court cases. Yes, I did. Very excited and proud about it. Some of these cases I'm going to talk to you today about, particularly the Fourth Amendment, because I think it's really timely to talk about the Fourth Amendment and our right to be guarded against unreasonable search and seizures. So interesting enough, why is this timely? The framers decided, right, that we should be secure in our person, our property, our papers, and our effects from the government coming in arbitrarily and seizing these things without notice, without some kind of standard in which to be able to act, right, to seize these things. So this is important, and I kind of want to stress and go back again. I'm a history buff on why the framers thought it was important for us to have this secure right to privacy. Okay, let's go all back to 4th grade a little bit. What did the framers experience, guys? What was going on during that time that many of them said, we, the state delegates, refuse to ratify our Constitution if we don't have this amendment in our Constitution? Does anybody want to kind of chime in on what was going on?
British occupation enforced requirements of funds and property for the troops.
Right. So if I heard you correctly, right, British agents were going crazy. They had the right, they could come into anyone's property without notice, very arbitrarily, and seize your property. Has anybody watched, no, I'm going quickly. Has anybody watched Turn? It's a series on Netflix. Are you kidding me? Who has Netflix? Okay, watch Turn, please. That's right. Okay, when you get that hour on Saturday night, right, when everybody's out partying, turn on Netflix, watch Turn. Because what you will see is that oftentimes British soldiers went right into the colonials places and were able to just take things in the name of the king. Okay, and so the framers obviously wanted to guard against this. And they said, if we are going to be subjected to searches and seizures, there's a standard, right, that the government has to meet. They have to, a law enforcement officer has to go to a judge or a magistrate and present probable cause, right? They have to provide some type of evidence or to say that if they go and do a search or a seizure, that there's a likelihood that this will produce some kind of evidence of wrongdoing. Secondly, they have to be someone who has taken an oath to either serve or protect, or in fact have some kind of, be subjected to the court in a way, right? But more importantly, when a government agency goes for a warrant, they in fact have to be specific. Okay, they have to have a target, a specific person, a specific place, specific document or types of documents. Okay, so the whole purpose of the Fourth really was the framers saying we feel that you need to be guaranteed a certain right to privacy, right? Unlike what they experienced under British rule, they wanted you and I to have dignity and respect in our security, in our property, right? So in fact, this security, I'm going to use an example of a house. The security, if you will, is the front door. You have a right to be in your house, and your door is the security from a law enforcement agent coming in and busting through, right? You have that security, that door is there. The privacy piece, I'll use the window panels as the privacy, as a representation of privacy. You have a right to close your window panels and keep all the information and all the personal matter inside of that home personal. You have a right to not be forced to disclose this information. We're in a very interesting time because a lot of us have decided to keep our window panels open and disclose a lot of information. Matter of fact, most of us are actually bringing cameras inside of our home and streamlining all of our private information. So that goes back to my original question of what's private. And we have to start thinking about what is a reasonable expectation to privacy when we are opening the blinds ourselves and letting people in, letting the public in. So before we even get to the reasonable expectation to privacy, I wanted to ask you guys some questions. When you start peeling back the layers of the Fourth Amendment, right? If you start reading between the lines, what's not written, but what you can obviously see is that the framers had this mistrust of government, right? You guys agree with that? Okay. So there was this underlining mistrust because of their experience. What's changed since the 18th century? So we've become, go ahead, I want to hear your thoughts.
Technology has changed.
So we've become open and transparent through technology.
I was going to say the government's gotten a lot bigger.
Gotten a lot bigger. Do you think we trust them more? Okay, somebody says we trust government a little bit more, right? Because you can now see that we have Instagram, Facebook, we have our cell phones, and we are posting information that used to be very private. It now has become very public. And I say that because I'll go on Facebook and I just noted a friend has been cancer-free for 3 years, right? What used to be very private, like your medical history, is now very public. I have had a friend say she's been sober for 2 years, or I just quit smoking today, but I might start tomorrow, but just cheer me on. Or people saying, come to my divorce party, right? Like things are now really, really out there. And what's even more interesting is that this information that we think we're sharing with just our family and friends, do you think we're sharing them with just our family and friends?
No.
How many of you guys, be honest, safe space, remember that. How many of you read the privacy notice or the terms of and conditions? Is this a safe space? Are you really, you guys both are telling me you read the privacy notices? When you download an app,
Yeah.
when you,
Yeah, I don't use any social media because of that. So
okay, so 2 out of maybe
There's also lots of tools out there that'll basically, or a lawyer has looked over these privacy notices and condensed them.
There's also lots of tools out there and resources for people that actually you can just put in the site name, and a lawyer has gone through and just condensed that privacy notice down to a congestible portion for regular people. So that's very helpful. There's probably extensions you can download that automatically give you that smaller, shortened down portion, but I feel like it's important to read.
Now wait, I'm a lawyer. Which app or what website are you talking about where the privacy notice has been looked over and condensed and put in plain language, excuse me.
I'll have to find it. But
Please do.
Yeah.
I'll leave my contact info. Because I'm going to tell you, even as a lawyer, I do not read the privacy notices. I don't have 6 hours to comb through 92 pages. Okay? The truth is, many of us don't. We just want the app, right? Or we just want the platform. So we download Snapchat. We sign up for Facebook. My kids tell me that Facebook's no longer cool. So whatever the newer social media platform is, and we have yet to really look through and see or read that we've given these companies the right to share and sell our data to third parties that we don't know about, not connected to, right? So our information could be anywhere. Antarctica can really know that I celebrated my birthday. Someone in Antarctica can know that I celebrated my birthday a few months back, right? And what I did. So going back to what our framers, in fact, demanded that we have protection against, right? That was unreasonable search and seizure, and this idea that we are secure in our privacy. What happens when we don't even take the security seriously, right? When we are not really keeping what's private. The question that I really want you guys to think about is, do we have a reasonable expectation to privacy? I hear some people saying yes. Well, let's talk about some case law. I really want to start digging into the cases now to kind of hammer out what type of reasonable expectation we have. So in the 70s, the U.S. Supreme Court looked at U.S. v. Miller and Smith versus Maryland, and we were introduced to the third-party doctrine. And essentially, these cases said that when you share your information, certain types of information with third parties, you have made that information somewhat public, right? It's less private because you have shared it. So you really can't expect privacy to that data. In Miller, Miller was a guy who was suspected of tax evasion. They thought he was running a distillery. So the federal government went to his bank and pulled his bank records, okay, without a warrant. What they did use was an order under the Stored Communications Act. So the SCA says that the federal government can go to a judge, and a judge is required to force disclosure of a third party if, in fact, the government is using this information is relevant to an ongoing investigation. So essentially, this order is kind of a step below in terms of standard of a warrant. So there's no probable cause. You just have to say, well, the information is relevant to something we're looking into. So Miller, of course, was convicted. And the court said to him, Miller, I understand you are asserting that this was an unreasonable search and seizure. You had a right to think that your deposit slips and your withdrawal slips from this bank was private. But the truth is, this bank was going to record this information in their normal business operations, right? On a day-to-day basis, they collect how much we withdraw, how much we deposit from whom and to whom for their own records, because they have to submit reports, federal reports with this information. So once you shared it, you couldn't have possibly thought that it was going to be kept private. That makes sense? Somewhat. I got some heads nodding. In Smith versus Maryland, it was somewhat similar. The law enforcement team went in and were able to get information using an order, not a warrant, from a telephone company. And they were able to get the telephone numbers from the records of telephone numbers from a house, all the calls that had been made in from this house. And the court said to Smith, well, Smith, they did not record the content of your call. So if you were talking to someone and were having conversation, then we can see that you had a reasonable expectation to privacy for the content of your conversation. However, when you signed the contract with the telephone company, you knew that they were going to be collecting the number for you, right? Because they needed to collect the number in order to connect you to the person you're communicating. So you don't have a reasonable expectation to privacy. Make sense? So what we do know, based on Miller, based on Smith, is that if you start sharing types of information, don't expect that you have a reasonable expectation to privacy. Go ahead.
How long ago
How long ago were those court cases decided, and how does that still apply today if those court cases were really long ago?
That is such an excellent question. So those questions were, I think the Smith case was 1970, Miller was 1976, and Smith was 1979, okay? And obviously at that time in the 1970s, people were using landlines, right? There were no cell phones. So that's a very interesting question in terms of how does that, those decisions affect new technology, right? And we're gonna get there. So talking about what's private information? Because we've made everything so public, states have actually had to come and pass laws to help us figure out what is private information, what information should be protected. So a lot of these definitions, you guys have heard of PII, right? Personal identifiable information. Several states have decided that information like your name, first and last, date of birth, any of your financial records, passwords, medical information, your signature, biometric data. So your signature or your voice when you're being recorded. Have you ever called in to get service and they tell you this line is being recorded? Well, in some states, that actually is personal information that should be protected. Okay, so I'm sure you guys are looking up all the states' privacy laws considering what you're studying. Yes, you guys are on it. So the states have had to help us define what's private information because we've made it so public. So with that said, with the help of the states to determine what should be private and protected, we're going to go back to that question you had with how has past cases that really dealt with outdated technology applied to cases now? In 2018, the U.S. Supreme Court heard Carpenter versus U.S. And I put location, location, location because, guys, we carry our cell phones everywhere. So I'm going to give you some facts of the case, but we're going to really walk through because I really want to hear what you think how the case should have been decided and get some feedback, okay? So in this case, there were a string of burglaries in Michigan and Ohio. Law enforcement was able to arrest 4 suspects, none of which were Carpenter, the petitioner in this case. One of the suspects went ahead and confessed to the robbery. And so what the cops did was they took his cell phone and they went to, with an order, not a warrant. I gotta keep saying that because a warrant, you have to meet a certain standard, right? So they go with an order to the third-party wireless company, and they want to get his cell phone records to see who he called around the times of the robberies, right? Makes sense? Why are they trying to get this information, guys? Why?
So they can see their accomplices.
Exactly, right? They know it's a string of people, it's been a string of robberies, so they get this information. And from these documents, they're able to see about 16 numbers that appear to be suspicious. These calls were made around the time of the robberies. From this information, they were able to pick up Carpenter's phone number, okay? And you guys know what these cell towers do? Like these cell towers, when you make a call or use your GPS, they are tracking your location. And the cops determined that, they were able to determine that Carpenter was in close proximity to several of the robberies. Needless to say, he was convicted and received about 116 years in federal prison. Okay. So let me ask you, he has a cell phone. We all have cell phones. You have to sign a bunch of paperwork, right? When we sign those phones. Do we know what we're signing? No. Well, let me just tell you that you are telling the third-party service provider that they can extract information from your phone and provide information to your phone in order for them to deliver their services, right? In order for them to use GPS, in order for them to help you troubleshoot any problems you may have with your phone. So you are signing on the dotted line. You are consenting to the phone being accessible to the third-party provider. You're voluntarily giving this information up. Should you have a reasonable expectation of privacy to that information? I see a no. Can I get a why?
I mean, the right to privacy assumes that you are choosing to keep that private. So when you choose to give up that private information and make it public, I don't see any reason why you should have right to privacy in that case.
Okay. Any other thoughts? And you're saying essentially because he decided to carry a phone, he knew that he was giving up information.
A company chooses to provide services and they state what their basis for providing those services are. They should be allowed to say, it's a company. They want to provide these services. They need to do X amount of things. If you choose to accept those terms that they give you their service for, I see no reason why they can't use your data in whatever way they see fit.
Interesting. Does anyone disagree with that?
I believe that the problem with all these things is that, sure, you're signing these documents and stuff, but you don't know. They're like, oh, just sign these documents. Go, 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 go. It's like, also, if you try to read them, you're probably going to be like, what am I looking at? I have no idea what I'm looking at. I think what we need to end up doing is making a law to make these contracts more like plain text and make it, in a sense, more binding, where it's like, if you sign this, you completely give up all these things defined. But I feel like the problem with our current society is with all these ones that people don't understand. They don't understand what they're giving away. They're pretty much signing away the right to who knows what.
You must have read the GDPR, right? So this is exactly what the European Union has said in the General Data Protection Regulations that they passed 2 years ago. Now, they are requiring companies who collect data from European residents, they must provide a privacy notice in simple, plain language, right? So you're really spot on in what European Union has decided the direction they're going to go. Is because when you're buying a phone and you have, 30 minutes to make the transaction, and they give you 18 pages of legalese to read, you can. You're right. And you're absolutely right. You have the right to walk away and not have a cell phone and wait at home at your landline for any call. You do. I don't disagree with you. I absolutely don't disagree with you.
We don't have an inherent right to a phone.
That is true. You don't have an inherent right. You do have an inherent right to privacy. Right? That's what the framers demanded was in our Constitution.
And that's why we have to sign those forms. We have to sign over or at least acknowledge that we know we're giving up certain rights to privacy or whatever else.
Go ahead.
I was recently at a privacy talk in New York, and there was a lot of different panelists, and one of them was a NSA lawyer and policymaker, and they kind of focused on how you don't have a right to privacy in the Constitution. Wow. So do you understand, or could you give more information on their point of view in saying that, well, actually, it doesn't specifically say that you don't have a right to privacy?
So very interesting. That point has been made on the Supreme Court. Okay? And there are judges who believe that the Fourth Amendment has been interpreted too broadly because, in fact, it does not say you have a right to privacy. But case law has inserted privacy in the context of the Fourth Amendment. So I want to tell you, first of all, just quick guess. Do you know, someone just give me a guess on how they think the court decided on Carpenter. He was convicted, he appealed. Any thoughts on how the court decided on this case?
It was perfectly fine.
He was, Did they need a warrant to grab this information? No. I'll leave the suspense. In a majority decision, 5-4, the court said he had a reasonable expectation to privacy. Okay, and here's why. It's going back to the type of information given. They said that the third party doctrine did not apply to this case because when in Smith, unlike Smith and Smith and Miller, again the technology was different. The types of information that was given was foreseeable. So I'm working with the bank and I should reasonably expect them to record my banking information, right? Because I might want to know how much money I had in there last year, right? And I'm assuming great service means that they can provide that information. Again, with the telephone company services, well, I need to make a call, so you have to have the numbers in order to connect me to my phone call. Remember rotary dial? Probably no one in here. But anyway, they actually had to record those numbers and manually put those in to connect. Go ahead.
So you're saying that because it wasn't the purpose of the service, the location is kind of an extra thing, then you have a reasonable right to privacy?
Right, so think about that. It was really about the type of data that was being captured and how intrusive that could be. Like, the government can now know, if I have my phone on me, where I am at all times. Bank records couldn't tell you where I was at all times, right? And neither could the numbers that I've dialed, essentially who I'm talking to and why and what I'm saying. It appeared to be a bit more intrusive. And so I'm going to read for you guys what Chief Justice Roberts, who wrote the majority opinion, said. Roberts argued that technology has afforded law enforcement a powerful new tool to carry out its important responsibilities. At the same time, this tool risks government encroachment of the sort the framers of the Constitution, after consulting the lessons of history, drafted the Fourth Amendment to prevent. Like, this is really the definition of intrusive. When I know and I can tell you at any moment, I can tell you actually what you did 2 years ago, because third wireless parties or third service wireless parties keep these type of records not just for days or months. They keep this information for years. Moreover, when they collected this information from the suspect who confessed and they obtained Carpenter's information, what the court said was, my goodness, not only were you able to determine Carpenter's location, you can determine the location of anybody really that was in the vicinity in which Carpenter communicated with. Does that make sense? So now this has gone from Carpenter, from first the suspect to Carpenter. Sorry, guys, that was my alarm. Wow, this moves fast. To other individuals who didn't voluntarily, right, provide this, who wasn't relevant to this investigation. Does that make sense? Okay, so I'm gonna breeze through this because I really want to get your take on these next two cases. Who has heard of the Golden State Killer? Okay, my goodness, I lived in California, born and raised, okay? So in the mid 70s, mid 80s, a serial killer ran rapid in California, okay? Committing, my goodness, robberies, murders, rapes. And it wasn't until recently, after 30 years on the run, that he was convicted. Anyone know how? Can you share that?
Anyone in New York?
Yes. The law enforcement was able to take the DNA left at the scenes of the crime and plug it into a genetic testing site, very much like 23andMe and Ancestry.com, and they pulled up DNA from his distant relatives and was able to narrow down, right, after filtering through and getting out, eliminating people through alibis, to two people and eventually to him. Unreasonable? Does he have a reasonable expectation to privacy of his genetic makeup? What gets more private than what's inside your body?
He decided to leave his DNA at the crime scene.
Well, that's true. Good point. Good point. But let me ask you, it was his relatives who voluntarily gave up their DNA. Okay? And so, if they voluntarily gave up their DNA, did he actually have some type of expectation? Well, I guess your point is very well taken. He actually left his DNA. That was the best. I thought I was going to stump you guys with that.
Doesn't it go one step further, too, that after they had identified who they thought this person was, they then snagged his garbage and went through until they found something with his particular DNA on it?
So they did.
So they could say, we know that the killer was related to these people who say, we know this is the killer because.
So you're absolutely right. They did dig and find his particular DNA to confirm, in fact, that it was him. And another thing is when you put your trash out there, don't expect to, it's now public. And so anybody can rummage through your trash and get that information. But let me ask you, is there any level of intrusiveness in this case at all? Your thoughts?
I'd say if the records are already there from the people that put that information online, those distant family members, when it comes down to him, I feel like everyone else involved that was innocent that they looked through to get to him, their privacy would have been violated.
That's interesting and very interesting. I've done DNA testing before, but does this make people pause, right? To think that I'm giving my DNA now and could somehow be incriminating or releasing information of my future grandkids at some point, right? Who knows? Like, is that alarming? Is that, and I go back to that question, intrusive, right? Because what consent does my child or grandchildren have if I've released my DNA that we happen to share, but it somehow implicates them in some future activity? Is this in fact what the framers were trying to guard against? I'm just putting that question out there for you guys to ponder. Anyone heard of the Alexa case, the murder case involving Amazon's Alexa? Yes. This is interesting, right? So I'm going to just kind of run through the details, but two guys watching a football game. One was invited over to watch the game. Long story short, one of them ends up dead in a tub. Neighbors or witnesses said they heard Alexa playing, right? So Alexa was playing music. And I don't know how if you guys are aware of this, but Alexa's always on, right? Always operative. And she serves as this assistant who can order your groceries, play music, make appointments for you. And she's recording this data. When you talk to her, she's recording this data and sending the information on through whatever app or third party you've signed up with. So in this case, the prosecutors wanted to have Alexa's recording admitted as evidence of what went on during that time, right? Because she would have recorded noises. And while we weren't there, Alexa was almost like the third eyes in the room, right? What do you think? And for those who are aware of the case, what are your thoughts on if this information should be allowed in this case? Is it intrusive?
I think the problem with this case is that not everything, like noises or things you say, like are actually like something that you would like normally say, and it's like it's not what like you can take something as something, but it doesn't always mean that's what it is. You don't have enough I don't think you have like enough context to be able to prove it. Like you're not actually there. Like you're just pretty much hearing back a video recording. Like you don't know anything like the context or anything. So who knows what it could actually be?
Well, I agree with that, but let's take it a step back to one of the first slides I showed you. You're in your house. Your blinds are drawn. Remember that? You have this right or this idea of being secure in what you disclose. So Alexa is picking up noise, and who knows what Alexa picked up? Maybe she picked up arguing. Maybe she picked up a thump. Who knows what she picked up? But whatever she picked up, did the suspect in the case have some expectation that whatever happened and whatever Alexa captured stayed in that house? Go ahead.
I think putting an Alexa in your house is, in the house example, the equivalent of installing a big open window.
That's interesting. You agree? You're shaking your head. Okay. But when you sign on to Alexa, and let's say you order your groceries through Alexa, the information you said I'm providing is to who? Amazon, right? And specifically the information is my grocery list. Not that I listen to Luther Vandross when I'm mopping my floor, right? And so the type of information, remember we're going back to what type of information have I consented to? What type of information should I have a reasonable expectation to privacy for? Any thoughts on how this case, what happened with the Alexa? Was this evidence admitted into trial?
I was just going to say, you still sign a privacy and consent agreement whenever you buy any product through Amazon or use their services. So it goes back to the same thing where they're a company providing services and creating a product, and whatever information they choose to collect, I believe that's public information, along with his analogy of the open window. You're essentially giving up your right to privacy by putting Amazon into your home, because as long as it is in whatever statement they give you that you sign when you buy the Alexa, the Alexa AI object, I don't see any reason why you should think that should be private.
By a show of hands, how many of you think that the evidence was admitted into court? The rest of you think that it was not admitted into court, right? And you're correct. The judge would not allow the evidence from Alexa to be admitted into court. And it's, you know what, guys, this is very interesting, and I'm so appreciative of you guys sharing your insight with me, because I'm starting to think, with all this technology and the fact that we consent to using it, using social media, are you guys of the mindset that we are, in fact, jeopardizing or giving up our right to privacy under the Fourth Amendment? And are you okay with that? I feel a little, you know what I mean? I want to go talk to the framers and talk to them a little bit about, should I be scared? But go ahead.
I feel like in today's day and in the future age, it's safe to automatically assume that once you put that information out there, it's going to be viewed. So it basically comes down to the customer or the user to be able to say what they want to be public and what not to be public. So if they want to put an Alexa in their house or if they don't. And then it comes to the privacy of the companies and how they are going to treat that user information. But things need to be transparent to gain customer trust. So they'd be able to trust that product and say, okay, even though this information is being recorded, I know Amazon is reputable, for example, and that they will take care of my user data and delete it after a certain period of time and not store that for a long period of time. So it just gets down to consumer and company trust.
So I know this didn't align with the outcome of the court case, but you know, if Alexa/Amazon collects this information and the authorities believe a capital crime has taken place and they file the right legal paperwork and say we'd like to take a look at this is why, and a judge says yes, this is reasonable, okay, you can have that. And I know the court didn't go this way. I have less concern with that than Amazon actually collecting all my information, deciding what they're going to try to push to me to sell. I'm much more concerned about what Amazon is doing with my information than if I were to do a crime and the law authorities tried to glean that information to figure out what I had done.
It's so funny that you say that in terms of should we be worried about all of the information that we're putting out there? What are third parties, what are these companies that we're consenting to doing with our information? And I think that's exactly why the GDPR was passed, right? So I don't know how many of you have read the regulation. It's long. But essentially now, for European residents, they have the right to not only go to a company that they've allowed to store their data, they can tell the company, I want to know all the information you have on me. I want to have you delete that information. I don't want you to share or sell that data. We are so far behind. First of all, do you think that the United States should adopt those type of regulations? I see no, I see.
I know when I was talking to the same guy, he said, unlike Europe, we don't have a specific right to privacy because they implemented a specific right to privacy along with the GDPR and everything else like that. It was basically strictly saying that they have a right to privacy versus kind of a vague allusion to that without using the word privacy, and then everything else that was built on top of that to kind of push the Fourth Amendment, saying that it went in that right direction. I think that once we start catching up with the GDPR and pushing individual state regulations saying that, yes, there is right to privacy, companies need to look at this and be able to talk to the consumers, that we're going to be able to catch up with that.
Well, it's very interesting, and I'm going to ask this question. Go ahead, I'm sorry.
So in Europe, there's GDPR, but in the US, it's a lot more industry-based. So like you have HIPAA for medical information, you have, like, is it FERPA for education, for
students, I believe
for student documents? Yeah, right. So it's like kind of as the need arises in each industry, it seems like that regulation comes up rather than having one overarching.
But do you think that's enough? Look at the headlines, right? Look at the fact that Facebook, Google, and who else is the other big three in technology? They have had to testify before Congress more often than they wanted to talk about what they're doing with our data and our information. There is concern out there, right? And to your point, someone said that once you put this information out there, it's just out there. So is it too late for us? I mean, because if I've put my information out there, can I really go to a company or to Facebook and say, I want you to delete everything you have on me? Can they really do that when people tag and post and share all types of information? Go ahead.
I feel like the problem with the U.S. is that we always seem like, at least in the federal level, we always go for like reactive solutions to our problems. Like, we're never like thinking in the future. We're always just thinking about, oh, this happened, let's do something about it. Like, we're never thinking
immediate fix.
Yeah, we're never thinking of we're never thinking one step ahead. We're always thinking, all right, yeah, something's happened. We're gonna go fix it now. So I feel like the problem needs to be in the U.S. just thinking forward to be able to think about things before they come up, for them to actually start thinking more about privacy and all that.
That's a good point. Well, guys, I want to allow you to ask me any questions about the cases or even your thoughts on the Fourth Amendment. I heard a great point. It has been said that the Fourth Amendment really doesn't protect. It really doesn't offer a right to privacy. Obviously, the Supreme Court differed with that opinion, right? In the Carpenter versus United States, saying no, you do have a reasonable expectation to privacy. So as we go out and we continue to use these platforms and technology continues to develop, the courts will have a hard time trying to figure out how to balance the interest of government with that of the people. Okay, but to your point about, well, I understand. I'm more okay with what with law enforcement and the government does with my information. Should I really be concerned with what these private companies are doing with my information, and what kind of rights do I have there? California just passed a similar version of GDPR. It'll be very interesting to see how that plays out, right, in the next few years. So I'll open it up for questions now.
So taking your last point there is that when GDPR was implemented in Europe, we saw an awful lot of the companies, many of them US based, just saying it's much easier to manage one privacy policy, so making it's not a law. But do you believe that the case, this new legislation in California will push even more of that? You know, the internet doesn't necessarily recognize a border. I mean, when you jump online and surf, these people don't necessarily know where their customers are. So how can they immediately say, oh, well, I need to use a different set of privacy rules because this customer is in California versus the guy that was just on here from Indiana? So do you believe that the one state's legislation may push virtually that it becomes a standard?
So what I think California has forced many states to do was look at their own privacy laws, right? Facebook, the headlines, data breaches. More and more states, more legislators in the state house are trying to figure out what they should be doing to protect our information. And I think that has many big businesses worried, right? Right now, you have Google, you have Facebook, currently and in Washington trying to draft a federal regulation so that they don't have to follow these piecemeal patchwork laws in every different state. That would be incredibly burdensome. So I really do think that the federal government will tackle this issue because I just don't see how, to your point, any company can filter and decide, well, did this information come from Washington, Illinois, and then what state law do I apply to that, right? So this is my prediction, that you will see something similar to GDPR coming from the federal government in the next few years. Because if not, and it's already being talked about, that you're going to see many state privacy laws amended in 2019. And that is going to be tough. Anybody else? Go ahead.
What do you think about the new legislation that's being pushed in Europe, like Article, I think it's Article 13 or Article 16, what is basically the link laws? So it's kind of, they're trying to force the way websites link to other articles for copyright reasons.
Well, I will say this overall with what the EU is doing to police the internet. They're going to get many challenges, and they already are. So I don't know if you guys are aware that Google is challenging their right, the enforcement of GDPR. It's like how you have overreached EU. This is Google's argument, right? Because I'm over here and I don't really do data. I don't really work with the EU residents, or in fact, this is just so intrusive. This is so, you are now making your outreach global. And so to Article 13 and the rest, I think that the EU will have many more people or companies come forward in opposition. And then I'm curious to see what other companies, what other countries back that up, right? Because, hey, Apple, Google, Netflix, these are powerhouses, right? What is it? Amazon just reached $1 trillion in revenue and profits. Was it Apple or Amazon? So money talks, right? And then and these companies, these countries are looking to bring businesses and attract businesses to their country. You're going to see a great deal of opposition, and what will be very interesting is how. I think it's in France. They're challenging. I think the court in France is looking at whether the EU law, in fact, has overreached. And so look for that ruling, right, to see what else EU does in the future. Yes.
You mentioned a lot about some of the bigger companies, but in the summer I was working for a consumer product which was used in Europe too, and the argument that a lot of people are making against GDPR is that actually the big companies are more than happy to comply because it kills off their competition in those countries. Like EU companies aren't growing, American companies are just buying them or just streamrolling them. So I was just curious on what your thoughts are on that, because these companies have like 20,000 engineers. They're going to comply with anything and they're still going to achieve their main target. So I'm just curious how it plays into the overall growth of the tech sector.
Well, I mean, it's a good point, right? And I'd say that companies really, with something like GDPR, there's going to be a lot of resistance. However, if the United States follows suit and implements something quite similar to GDPR, then companies are really kind of in a short boat, right? Because in order to do work here in the United States, you got to apply to something very similar to GDPR. And in order to do work in the EU, well, you have the GDPR. So essentially, this either becomes the standard, this either becomes how we operate moving forward with protecting information, or it dies, right? I can't predict that. It really determines, and I'm curious to see how this administration, the current administration, reacts to GDPR. What type of, will if they do pass something, will it be watered down, right? Will we pass something for the sake of saying we passed something? Or would they fall in line, considering the headlines that we've seen come across these last few years with data breaches, and was it Cambridge Analytics having data, right? I can't predict the response, but I will tell you it is, whatever it is, it will be crucial to the success of GDPR and if it's implemented in other places, okay? I think I have like 4 minutes. My alarm went off, but are you guys okay with questions? You guys want to continue? I got another question here in the back.
How are the recent cybercrime investigations, and how does it affect the Fourth Amendment? Like, does it influence it in some particular way?
For cybersecurity, so you mean, can you explain a little more on your question, provide some more details?
A person, your privacy is at stake, for sure. So under the Fourth Amendment, people normally think that their privacy is secure. The information is secure. But when it comes to crime scene investigations, do the investigators get the right to search out of the warrant scope?
Do they get to search out of the
warrant scope? Yeah.
Warrant.
Oh.
Well, so the thing about the warrant is that you actually have to be very specific for a reason.
No, but when it comes in case of a cyber crime, so it's obvious that they will want to look into every other detail in the computers or network. So are they allowed to do it, or is that limited?
If I think I understand your question, it is, can the government operate outside of what's been granted in the warrant when it comes to cybersecurity?
And how does it affect the Fourth Amendment?
I will say that no law enforcement will ever tell you that they can operate outside of that warrant. right? Because that is exactly what the Fourth Amendment protects against, is to arbitrarily go after things. The judge or the magistrate gives specific authority to search very specific information or a person. So my first answer, I would say no. They would never admit that they've just went outside of their scope. In terms of the Fourth Amendment, again, that's the question. I mean, that's the question we have answered, is when you put your information out there, what type of privacy, what type of expectation of privacy do you have when you voluntarily offered that information to the public space? So that's the question that the courts are challenged with right now, right? So I'm going to pose that question back to you, because essentially this is about, some have argued that at this point in the game and future, we don't have a right to privacy, right? Unless you really withdraw off the grid, and I really might go to the woods, have no signal, no cell phone, use pigeons to communicate with people, because that is the only way I'll really get privacy. I'm joking. I'm not. I have Facebook. I post pictures of my kids every day. Guys, are there any more questions? Yes.
So with learning about legal practices concerning privacy, are there any resources you would suggest to us as students? Since I don't really have a deep law background like yourself, I'm not a lawyer by practice. I'm just a CS major. Do you have any resources or places you suggest we go to look to start learning about how law and cases are decided concerning privacy?
Oh my goodness. Type in Fourth Amendment.
Okay.
Type in Fourth Amendment, reasonable expectation to privacy, and type in modern technology. And you're going to find cases where the courts have struggled with, again, balancing government interests with the interests of the people. Do we have a right to cell phones? No, but the courts have said we have a right to our location being private. So think about, when you do think about these things, when it comes to reasonable expectation of privacy, I'll leave you with this. Think about what type of information you're disclosing, okay, to who you're disclosing it to. And in the event of, like I said, a bank record, understand that if your bank records are not your records, right? Do the company that I'm providing my information to use this information in order to provide me with services? They need this information in order to provide customer service. Or in the case of Alexa, the noises in my house has nothing to do with me ordering groceries to Amazon, right? So I have a reasonable expectation to the bumps that go on in my house, or even maybe not even the music I play, right? Because if I tell her to play Luther Vandross and that's somehow a warrant is asked for what type of music I listen to, let's just say, well, no, I don't really, of course, Amazon knows what music I listen to because I tell them to play the music. So just some things to think about when we start questioning if we have a right to a reasonable expectation to privacy. I saw another hand. No? One more?
I have one last question. I have seen recently, I think it's when you're crossing the border, police can ask you to use biometrics and scan your phone or do the Face ID and that kind of stuff, but they can't tell you to give over information like a password to enter your phone. So I know there's a difference between like the privacy of your thoughts and your right to remain silent versus them just being able to put your fingerprint on your phone.
That's interesting. I'll have to look more
Okay.
into that.
Yeah.
I'm not sure about the crossing the border, but that's very, very interesting.
Because I think like where that has been used before has been from even U.S. citizens coming back into the country and that kind of stuff. They're suspected they could be forced to like put their fingerprint to unlock their phone and other things like that.
Really forced to do it?
Mm-hmm.
Okay. I'll look into that.
Yeah.
So I think we're at the end of our time. With Jillian's permission, I'm sure she will take a few questions at the front of the room, but let's go ahead and call.
Thank you so much. I really enjoyed this.